Welcome to a paralegal counseling training. This is your host, Dr. Tulipo Mwenifumbo. Today we are looking at the defense side in the criminal court. So we are looking at the criminal proceedings, the court proceedings, and specifically we are looking at the criminal proceedings. So we looked at the uh, at the prosecution bringing in witnesses, and also we looked at cross-examination of the witnesses, prosecution witnesses. Now, today we are looking at the other side of the court proceedings. We said the first part of the criminal court proceeding is where the prosecution has to establish the case, which is called prima facie. So there must be the prima facie established by the prosecution, meaning that the prosecution must convince the court that the crime may have been committed. So it is from there, that's where now the court is going to make the ruling. And in making the ruling, the court may squash off the case or may put the accused on defense. Now, when we talk about the case being washed out, it is the situation whereby the court sees that the prosecution has not established the prima facie, which is has not established the case, has not brought in the witnesses, and they are not concurring to the suspected crime. And that is where now we are looking at the cross-examination. And that is the work now of the defendants to cross-examine the witnesses so that the case doesn't go into the other side. Now, here is now the case is established by the prosecution. Now, you as the defendant or as the accused, now you are put on defense. So the accused is now put on defense. I remember, as the paralegal counselors, we are there to we are not the ones to stand in court, but we have to help our clients to be able to stand in court with confidence. And the other thing that we have to know is that there is this sentiment, or there is this belief that the lawyers defend the criminals, or you as a paralegal, when you are helping the person who is accused in a criminal offense, on how that person can get out of that case. There is this general belief whereby people think you are promoting criminality. No, the purpose of law is to justify and to look at what the law states about a certain matter. If there was no court, then it was going to be just instant justice. When a person is accused, then he's taken to court without even passing the court. Now, the court is there to look at the evidences that are brought before court, and to look at the intention, which is the mind of the actress Mende and Manslayer. So that is the mind of the accused. Was he or was the crime committed intentionally, or what are the ingredients? What has made that person to commit the crime? Is it actual? There are a lot of things that has to be considered. I'll give you an example. One, a person being killed does not mean that the person has been murdered. For example, one is shooting on wanted to shoot, maybe, let's say, an empire. He has gotten the license and he was going to shoot the empire. Then he mistakenly shot a person, and that this person dies. That is not murder. That does not mean that that person has murdered that person, the other person. It was not intentional. So there was no intention of killing this person, but this person has died. So that's where now manslaughter and other things comes in. Now, as a defense lawyer, or as a when we are talking about the in a criminal jurisdiction, so when you are trying to help this person, they look at this person who has shot another person, and the family, what the family believes that this person has killed our person, and you are trying to help this person to understand, or the court to understand that this person did not kill this person intentionally. So the perspective is that you are defending the criminal. You see, so the work of the you as the people that are dealing or helping people in legal matters, it's not to protect evil or to protect crime, but to look at what the law states about an action. So that is the thing that we have to understand. Now, we are looking at the defense in a criminal court. So here is the accused, he has been accused. There are different cases which have got different defenses. So now the prosecution has established the prima facie, has established the case. Now it is the accused is now put on defense. Now, what should the accused talk about in court, or how should the defense be brought before court? Remember, our target as paralegal are the people that that cannot afford the legal fees. Now, it is number one in the criminal offense. I think I suggest that it is very important to be represented. If there is any means that one can be represented before court by the lawyer, that can be better than a person, one standing in person in the criminal offense. So now, due to the cost of hiring the lawyers, many people may not afford, and many cases especially in the magistrate court, they go without any representation. So meaning that we have got a lot of cases that goes without any representation, and that is the reason why you as a paralegal counselor, you should be able to have the understanding on how you can be able to help the clients, your clients who are the accused. Before looking at the different types of defenses, I want us to look at first that that it is not up to the accused to bring evidences on why he has not committed, on how he did not commit a crime. So the prosecution, they are the ones who should bring evidence before court. They should bring the exhibits before court that the crime was committed. So it is not upon the defendant or the accused to bring in the defense. For example, one is accused of obtaining money by false pretense, and maybe he runs a registered company or a school which is registered and which has got everything. Then the prosecution has brought in the matter before court that this person has stolen money or obtained money by false pretense, whereby this person, the institution is not registered and whatever. So now, it is not you as the accused to prove to the court that you are registered. It is the prosecution that should prove to the court that you are not registered. So, in the defense of the defendant in the criminal offense is not supposed to align himself to what the prosecution has brought in. For example, if someone, you were seated somewhere, then one loses the phone, and one is accused of having stolen the phone. So it is not you as the defendant to start saying that, no, we were many, there were 5 people, but I don't know why they have brought me in, because there may be others. That shows the possibility that you would have stolen, or you can steal, because you took advantage of other people that were there. So it is not your duty to talk about how you did not steal, or how you did not commit the crime. So it is the prosecution to establish that. And the duty of the defendant is not to talk about the issues that the prosecution has brought in, or in agreeing to the issues that the prosecution has brought in. Obviously, the prosecution have established that you are the ones that they suspect, and you are the one that got that phone. So it is not necessary for one to begin to talk about the incidents that the prosecution have established. Now, the duty of the defendant in a criminal offense is to talk about, like in that incident, is to talk about what transpired, how he was brought in, how he was accused of this. Him not knowing about the incidents, not knowing the reason why he is accused in this matter. Not talking about where you were, how you did not steal, and what. No, it's you to talk about why you are not involved in that case, why you are not supposed to be part of that, why you are not supposed to be accused of that, not how you are not supposed to be accused. So those are the mistakes that many people make. They want now to begin to discredit what the prosecution brought. You can only discredit what the prosecution witnesses and evidence during the trial, during the time they bring the witnesses. Make sure that you discredit what the prosecution, the witnesses that the prosecution has brought. But when it comes to defense, you are not supposed to start now discrediting what they were doing. You are supposed to talk about the things that does not connect you to the crime or to the incident that occurred. Not the things that may connect you to that incident. So that should be taken very important. Don't talk about the issues that can connect you to the incident, but talk about the issues that does not connect you to the incident. So that is what the first thing to be established in a defense of any criminal offense. Now, an action does not mean that the person has committed a crime. The action can be done by the same action can be done by 2 people, but one is acquitted, the other one is not acquitted. Why? Because an action does not permit that person is guilty. For example, here are 2 people. They have shot persons. This one has shot a person and this one has shot a person. Then the other one is acquitted, the other one is not acquitted. What is the difference? This one shot this person intentionally, the other one shot this person by mistake. But the true and the fact is that there are people that were shot and they are dead. So those are the Other things. So now I'll just give some examples of some cases that defenses in some cases in the criminal jurisdiction. So there are two types of defenses in a criminal jurisdiction. There is justification and excuses. So in the criminal jurisdiction, it's not always that a person should deny the action that was taken, but sometimes there are excuses that has to be in that action. I'll give example of the incident of assault. Here is the medical report. There is a proof that the person was injured, and you are the one that injured this person. So in that case, there is no need for you to refuse that I did not injure that person. So you have to use what is called excuses or mistaken. Maybe when you did not intend to injure this person. You injured this person by mistake. Maybe you were just throwing a stone at a bed, then it hit a person, then you are accused of assault. So you have to give the excuse. There must be the excuse on why that action was committed. So now it's not that always those excuses must be can be admitted, but the excuse has to be given. So the excuses that can be given, it can be given the excuse of insanity. Maybe you were not in the right mind, or this person that has committed this crime was not in the right mind. And also there must be, maybe it was it was a mistaken fact. That cannot, it can never be an excuse that I hit him because I thought it is another person. That is not, you are not allowed to hit any person or to injure any person. So that cannot be an excuse. So you have to give the defense on why you committed that. And the other defenses, like in the assault, it is self-defense. Now, when you talk about self-defense, it has to be established that you are in danger of death or being harmed. You cannot give the reason of defense in the day when people were watching and everyone was there. They were even clapping their hands, and your one says that it was self-defense. Yeah, it can be like that. Then you should have witnesses that should attest that it was really self-defense, where the witnesses should really satisfy the court. But mostly, in such a case, self-defense can only apply whereby you were alone with this person, or it was in the night, and all those can be the excuses in the assault case. In the so basically what we are saying is that when you are dealing in the criminal defense, you should not do what is called self-incrimination. Now, although the court does not the law does not allow self-incrimination, whereby a person incriminates by giving a testimony to the court, incriminates himself by giving the testimony to the court. But it is very important to talk about things that are going to take you out of the case, not things that are connecting you to the case. So as paralegal counselors, we have to educate our clients that what they are expected to talk about in court is how they did not, how they are not connected to that crime that they have been accused of. So they have to be away from the accusation that they have been accused of. You know, I've heard the situations whereby this person is accused uh, of rape. Then this person is saying, no, the time it was happening, I was not there. Then this person was convicted uh, because how was he not there? You see, how was he not there? So he's talking about the matter which is uh, uh, the he's talking about how he was not there, but instead of talking about why he is not involved in that crime, why he is not involved in that crime, not how he was not there. So those are the things that has to be considered. It is you cannot determine only because the actions or the ingredients of a criminal offense, they differ from one offense to another. That's why it is very important to do criminology or criminal law. So I invite you to do criminal law for you to know how to the ingredients of criminal cases, and also where you should look at the criminal procedures, and also you look at the penal code. That is the thing that can help in helping your client as a paralegal counselor. Thank you so much. I think we end here. The last thing that I want to talk about is that in every case to be sound, there must be witnesses that the defendant should bring before court. But it's not always that the defendant should bring the witnesses before court. Thank you so much, and we conclude on the criminal court proceedings.